The broadcast is now starting. All attendees are in listen-only mode.
Good morning, and welcome to Leavitt's and GBS webinar on potential audits by the Department of Labor, the Internal Revenue Service, and also HIPAA audits by OCR. My name is Lisa Klinger. I'm one of the benefits attorneys at the Leavitt Group, and today is October 20th, 2016. As the initial announcement told you, all attendees are in listen-only mode. If you want to ask a question, please type it in the box, and I will try to check questions after each section and then again at the end. If you do not already have a copy of today's presentation and you want one, please request a copy from the Leavitt or GBS advisor who sent you the invitation. I know they will want to follow up with you. The webinar is being recorded, so if you want to hear it again, or if you have colleagues or friends who missed it and want to hear it, you'll get a link to the recording. The email should be sent out tomorrow. Also, we do offer free client and prospect webinars every so often. And the next one is, I believe, about November 20th. I'll check that date exactly. And they're usually from 10 to 11 a.m. Pacific time. So again, today's webinar is Potential Audits, DOL, IRS, and HIPAA. And the webinar is being recorded. And let's see if I can get this to work. There we go. I seem to be having some issues with my computer. It's making little ticking noises, so hopefully that isn't being picked up too much on this recording. The general agenda is, first we'll have some general audit considerations, then I'll talk about DOL audit items, potential items, then IRS potential items, and then HIPAA items. And then I'll do a quick wrap-up at the end. So first, some general audit considerations. So the IRS and the Department of Labor have said that they'll be auditing to monitor compliance with the Affordable Care Act provisions, the ACA provisions, and also with provisions that were in effect in the ERISA and the Internal Revenue Code before the ACA was enacted. And the OCR, the Office for Civil Rights, which is part of CMS, Centers for Medicare and Medicaid Services, which is part of HHS, OCR has been sending out notices since March of this year for its Phase 2 HIPAA audits. And it has said it will continue to do so through the end of 2016, excuse me. So the question is, do you know what you need to do in order to be compliant and to document your compliance? Well, one thing you can look at is Leavitt and GBS have a document, 4-page document that we call the Ducks in a Row document. It's specifically on DOL audits, but a lot of these things will apply because the IRS will be auditing many of the same things. So a lot of them will apply even if you're not subject to ERISA. For example, if you're a government plan or a church plan. So I'll go over some of those differences. Also, just as a general consideration, keep electronic or paper folders, or a combination of both, with the documentation that's requested for these different audits, and I'll be going through what that is in this webinar. And don't wait until you're audited to start setting up these files. Even if you can spend 15 to 30 minutes a day or every few days getting your files in order, it should be information and documents that you already have, but maybe a good way to organize them is kind of the same way that the DOL or the IRS would be requesting the information if they do audit you. So if you already have them in those folders, then it's easy to just produce it if you're audited. Let me just jump one page ahead first. So this is the ERISA Ducks in a Row document that we have. So maybe you've seen that. And that's why we call it the Ducks in a Row. So I'll come back to that in a minute. If you do get an audit letter, what should you do? Well, first, determine if you have the documents that are being requested, or if you have to get them from other entities. And if you do, then call those other places as soon as possible. For example, it might be your broker, your insurer, your TPA, third-party administrator, or if you've had different carriers in prior years, then you might need to call several, either your broker or several different carriers to get the information. And the other thing would be, did you work at your company for all the years that are being audited? Or do you have to go back through someone else's files and see if the information is available? The agencies will usually, the DOL and IRS will usually ask for the current year and the past 3 to 5 years. And the HIPAA audits are usually just asking for the current year, and then they can request data or documents going back several years. The second thing, if you get an audit letter, designate one person in your office to be the contact person so that you don't have several different people calling the auditor, because that's more confusing for them. But also call your attorney, especially if you think there's a potential problem or with prior compliance or lack thereof, or if you think that the audit may be because a disgruntled former employee filed a complaint. So, and the other thing is, call the auditor and ask, can I ask what the reason is for the audit? They often won't tell you, but they might tell you whether it's just a random audit or if it's in response to a complaint. So, and often they may tell you that. And if you think or find out that it's in response to a complaint, or if you're aware of some potential issue that's lurking, you should definitely get your attorney involved and discuss with your attorney whether the attorney should be at the audit with you. You do have a legal right to have your attorney present, but there's no legal right to have someone else with you, like your broker or some other representation. The auditor can allow them, but they don't have to. And we've had clients who said, they had another outside third party, and the auditor said, no, you can have your attorney or no one with you. The auditor also can ask to speak separately to different employees, probably in the benefits department, to ask questions about how the plans were being run in operation. And the fourth thing is, be professional and polite, be cooperative and not confrontational, but don't give additional information that they don't ask for, and don't provide any additional information. Another thing is, if you have questions about what documents are being requested or how to provide them, maybe whether it's electronically or sending in hard copies, then call the auditor right away and get those questions answered, because you want to make it as easy as possible for the auditor to see the information that they want and go through it. And then if sometimes, especially recently, the time frame to produce the documents is pretty short. So if you feel it's too short and you can't get the documents together, then ask for an extension sooner rather than later. But I think don't ask if it's not needed. I know that some people suggest requesting an extension whatever the turnaround time is. I disagree with that. I think if you're organized and you can produce the documents in the time requested, I think that looks better to the auditor, and it shows that you are organized and you have the documents. But if you need the time, then definitely you should ask for it. So this is, again, what our ducks in a row bulletin looks like. And keep in mind that the agencies are auditing to see if plans and sponsors have been and currently are in compliance. So you should do a self-audit and get compliant where you're not already. And you also need to be able to document that you are and were in compliance. As the bulletin says, if you haven't prepared for your audit, you could be a sitting duck. This is the page 2 of the Ducks in a Row document, and you may have also just seen this as a separate document. It's the 5 steps to compliance. It's the flow chart of compliance for a DOL audit. But the similar rules apply for an IRS or a HIPAA audit. One thing is, are you subject to the particular law? Step 2 is your plan subject to the particular law, or is there some reason it would be exempt from some of the requirements? Or step 3 is the plan exempt from some of the requirements of the law. Maybe it's subject to the law overall. And then the 4th thing is do a self-audit. And the 5th thing, which you can't see on this, is get compliant where you are not. And then this is the audit checklist this is part of the checklist, and it's the items that the DOL requests in its attachment A when it sends an audit letter. And we also have a more detailed audit checklist if you want to set up folders or files and keep them in specific documents that the DOL will be requesting. So, potential DOL audit items. Let's see, there's a question, will the audit be specific to a certain benefit such as health plan or 401k? Yes, the audit will be specific to a certain health plan, and it would either be your group health plan or your 401k plan. And the DOL, for example, if the DOL came in and did an audit of your group health plan, it might find some issues that are really IRS issues. For example, the DOL handles more, specific mandates in ERISA, but also notice and disclosure and reporting requirements. And the IRS doesn't really have jurisdiction over most of the disclosure requirements. So, but it has jurisdiction over tax issues, or over the, say, the PCORI fee, or the employer shared responsibility requirements, and the 4980 A and B penalties. So if a DOL auditor audited your health plan and found irregularities or things that were also IRS violations, they would probably notify the IRS of the particular issues. And the same thing with your 401k plan, although it's more likely to be an IRS auditor who would initially audit your 401k plan, and then if they found irregularities, they might turn it over to the Department of Labor. And for your health plan, I think it's more likely you would initially get a DOL audit. Although let me clarify that by saying, except if you're an applicable large employer and your 1094 and 1095C filings that show any irregularities or non-compliance, that could trigger an audit. So let me get to that specifically. Let me start with the Department of Labor audit, since the ducks in a row document pertains specifically to that. But again, let me say many requirements in ERISA are also in the Public Health Service Act, the PHSA, and the Internal Revenue Code. So even if you're not subject to ERISA, for example, because you're a government or a church plan, you'll still have many of the same obligations. For example, HIPAA requirements, mental health parity requirements, and many of the ACA provisions. But you could have different penalties if you're subject only to the Public Health Service Act or the Internal Revenue Code and not ERISA. And I do have several pages on the penalties of each types of penalties. So potential Department of Labor audit items. This is an overview of the various areas that I think the DOL might audit. And it could be ACA, Affordable Care Act, and ERISA notices. Also compliance with the ACA market reforms and ERISA Part 7 rules. And the Affordable Care Act rules are generally effective the first plan year beginning on or after September 23rd, 2010. And I'll go into more details on these, but things like the annual and lifetime limits, the Patient's Bill of Rights, preventive services, MLR rebates and refunds, grandfather plan status, also wellness programs. And then another is compliance with the Mental Health Parity and Addiction Equity Act, and also with COBRA. And then not on your group health plan, but the DOL has certainly been saying they plan to do audits of 401k plans, particularly 401k contributions, and on the new overtime rules. Now, one of the things that the DOL has said is that they do plan to audit all the individual account plans. And those are like 401k plans, where individuals have an account and money is building up in it. I do think that the Department of Labor will also be auditing group health plans, but I don't think that they're necessarily going to audit all group health plans, but I think they're more likely to be auditing all 401k plans. So this slide has potential DOL audit items that were before the Affordable Care Act. And the Department of Labor conducted ERISA audits even before the Affordable Care Act was enacted. And so when the DOL sends an audit letter, they have this attachment A that's several pages long, and it includes all the items they're asking for. So many of those items are pre-ACA items, and then others are since the Affordable Care Act. The DOL also has a self-audit tool on its website at the URL that's listed here on the screen. And there's a part 1 of that and part 2. And part 1 is the pre-ACA stuff, and this is the URL. And part 2 is the Affordable Care Act requirements. So these are good things to look over just in doing a self-audit. So for example, HIPAA requirements, and that's the not so much HIPAA privacy, but HIPAA Part 1, the pre-existing conditions limitations, the notices about that, creditable coverage and notices about that, special enrollment provisions. If someone has an event, special enrollment event, they can enroll 30 days or 60 days if it's under CHIP, the Children's Health Insurance Plan. Also sending the CHIP notices. HIPAA also includes non-discrimination based on health status factors. And those are the provisions that the wellness programs are an exception to those general HIPAA non-discrimination rules. So there's also compliance with the HIPAA wellness program provisions. And just in the last year, so it's not pre-ACA, but it's other than Affordable Care Act, are the EEOC wellness program provisions under the ADA and GINA. Then other pre-ERISA things or pre-ACA items that the DOL would audit for, if you have a MIWA, Multiple Employer Welfare Association, or an association plan, guaranteed renewability of coverage, Mental Health Parity and Addiction Equity Act, and that's for all plans, or not for plans with fewer than 50 participants, although now the Affordable Care Act extended the requirements to small plans as well. And then other notices and requirements, the Newborns and Mothers Health Protection Act, the Women's Health and Cancer Rights Act, Genetic Information Non-Discrimination Act, or GINA, and Michelle's Law. So those are the kind of things that will, if the DOL audits, that would be included on their list, and those are the pre-ACA issues. And then, as I said, the DOL has this self-audit tool, and Part 2 covers the ACA items. So I have several pages on that. The grandfather status, if you're claiming grandfather status, you should definitely make sure that you can substantiate that your plan was grandfathered for the year or years that you claim it. So you would need to show that there's what the employer and the employee amounts were paid for coverage, and that you didn't reduce the employer amount by more than 5% below what it initially was in 2010. And then you would also need to show that you sent out the grandfather notices. And we do have, Leavitt and GBS have a grandfather documentation kit from 2011. So if that's something that you need, to contact your advisor, and we can give you that. The second thing is some of the requirements are what are known as the insurance market reforms, like the dependent coverage and the no annual or lifetime limits, no pre-existing conditions exclusions. So if you have an insured plan, your carrier no doubt made sure that the policy was compliant, probably back in 2011 and 2012, for example, covering dependent children to age 26. But you also needed to send notices in some cases, or the carrier needed to have sent them. So for some of them, there was a one-time notice, so be sure you can document that those were sent. And for example, if there were dependent children who had aged out, say at age 20 or 22, and they weren't students, but they needed to get a notice saying they could come back in because they could be covered to age 26 even if they weren't students. Or if someone was no longer eligible for coverage, because they had reached their lifetime or dollar limits, then they needed to be given the notice that they could come back into the plan. And generally those notices were just sent out to everyone. but that's what you might want to make sure. Let's see, I have a question. Can you explain Michelle's Law real quick, back on the prior page? So Michelle's Law was before the requirement that students had to be, or mean that dependents had to be covered to age 26. The requirement was that students had to be covered as long as they were, or dependents had to be covered as long as they were full-time students, like enrolled in college or in a post-high school accredited school. But what happened was, if a student was in an accident or ill and then was not a full-time student, then they would lose their eligibility for coverage, and the plan would disenroll them or offer them COBRA. And that was just when they needed coverage. The whole reason they weren't a full-time student was because they had an accident or illness. So Michelle's Law said you can't disenroll them for that reason if they would otherwise be eligible. And Michelle's Law is still on the books. It's just that since the ACA has put in the provision of dependent coverage of children to age 26, it doesn't really matter anymore because nobody's losing coverage just because they don't have full-time student status. Let's see. Oh, so back to this slide. Another area, as I mentioned, the DOL audits to make sure disclosure requirements were complied with. So one of those requirements is that the summary of benefits and coverage, or SBC, and the employer, the plan sponsor, or the carrier needs to be sure that that is given out. So what's happened is that, I'm sure you know, carriers usually provide it online, or they may provide a hard copy to employers, but it's up to the employer to send it out to the actual plan participants. So it's often in the contract that the employer is obligating itself to do that. So you might want to make sure that that notice has been sent or available, or that if it's electronically provided, that those rules are followed. And then the last thing on this page is the MLR rebates. So if a plan was insured and got MLR rebates, the medical loss ratio rebates, if some of the amount should be allocated to plan participants because it's plan assets, then I'm sure the DOL is going to be auditing for this. If your plan got rebates, MLR rebates, or other dividends, they're going to want to ensure that if those were plan assets, they did get allocated to participants. So you'll need to show what the plan language was, how you determined whether or not it was plan assets, how you determined what percentage went to participants and to the employer, and show how you applied those rebates. And again, we do have GBS and Leavitt have an MLR worksheet, just a little easy spreadsheet, and the documentation sheet where you just show, you fill in how much you got from what carrier for each year, and how you determined what percentage went to whom, and how you applied it. So that's the kind of thing that you would want to be able to document that you did comply. More potential DOL audit items, again from Part 2 of the tool, the Affordable Care Act provisions. Some of the requirements are the patient's Bill of Rights, the coverage of preventive services, and the Affordable Care Act claims and appeals and external review provisions. So again, if your plan is insured, it's probably, your carrier is probably making sure these were met. If you're self-insured, you need to make sure your plan was meeting the requirements and that you were giving disclosure notices. And the patient's Bill of Rights, the first one, includes the 3 requirements about the participating PCP, or primary care physician rules. It can be a physician, and secondly, the plan cannot require pre-authorization or referral for a female participant to see an in-network OBGYN, and third, that the plan must cover emergency services by out-of-network providers on the same basis as for in-network providers. And then the second thing is the coverage of certain listed preventive services, and those are listed by the U.S. Preventive Services Task Force, and the plan has to provide first dollar coverage paid before the deductible and no cost sharing. So again, it's probably something, if you have an insured plan, the plan was doing this, but you just need to document that the language was in your plan or your booklet or your SPD. And then the third thing is the claims and appeals procedures that they have to, the plan, for example, has to, it's a claim denial. It's called an adverse benefit determination. And the ACA does specify that that includes rescissions, and also the claim denial has to provide diagnosis and treatment codes and what they mean. And then if it's requested by a participant or the representative, then it has to be provided as soon as practicable, and you have to include an adequate description of why the claim was denied and what are the available claims and appeals procedures. So also on the claims and appeals, the plan has to provide notices in a culturally and linguistically appropriate manner, and so you just need a one-sentence statement in the non-English language about the availability of the language services. And there is and then provided in the other languages if requested, and for example, a consumer hotline where people could call in. And again, that's probably something, if you're insured, that your carrier is handling. If you're self-insured, probably need to check with your TPA so you can show that you were complying with those requirements. Now, potential penalties, if there's a DOL audit and they find a non-compliance, the DOL did issue an interim final rule on June 30th of this year, which increases the penalties for civil monetary penalties under ERISA and other labor laws that the DOL would have jurisdiction over. So this applies for penalties assessed after August 1st of this year, even if the failure occurred before then. And for example, the DOL penalties had not increased in a number of years, so they increased them for inflation. So for example, the failure to file a Form 5500 used to be up to $1,100 a day. Now it's up to $2,063 a day. That's if you don't use the Delinquent Filer Voluntary Compliance, or DFVC program. So clearly, if you find you have 5,500 you haven't filed, it would behoove you to use the DFVC program. And then also for failure to file the Form M1, failure to furnish information requested by the DOL, failure to provide the CHIP notice to employees, and failure to provide the SBC, Summary of Benefits and Coverage. You know, that could be up to $1,000 per failure. So you do want to be careful about making sure you're in compliance. The other thing is there are also other penalties and enforcement measures the Department of Labor can take. Probably with your health plan, there probably wouldn't be a prohibited transaction, but there could be if you have a trust, a self-insured plan and a trust, or for your 401k plan. There's a 501I penalty for prohibited transactions. That's 5% of the amount, and then if it's not corrected within 90 days after the DOL requested correction, then there's a 100% penalty. And then there's a 501L penalty if the DOL finds a breach of fiduciary duty in doing an audit, and that is 20% of the applicable recovery amount, and that's in addition to any other penalties. There's also, if there's an audit, at the end of the audit, the DOL could find or could issue a voluntary compliance settlement agreement. And that is often if there are reporting and disclosure issues or issues on bonding. And so there wouldn't be any civil lawsuit or any criminal prosecution by the DOL. It would just be a settlement agreement that includes, that says a statement of the facts and what the penalty would be, and it would require a notice to plan participants. So if there's an audit and you have some kind of settlement agreement, you also have to send a notice to plan participants that there was this DOL audit and what the result was, and then they also post it on their website. Another thing that could happen at the end of the audit is you could get a letter, a DOL letter that's an in violation closure. So it's a closing letter that says, yeah, they're in violation and they didn't agree to fix it or settle it. And then it also could be, the DOL can refer the issue to the IRS or to the DFO OE for litigation. in the DOL, it's the Division of Field Operations, the Office of Enforcement. Now, the Office of Enforcement could decide not to file a lawsuit, even if they get the closing letter from the auditor, but you don't want to take your chance on that. And then third, there could be litigation or criminal prosecution without attempting voluntary compliance. So that's if, again, I say it's unlikely, but if the Department of Labor auditor says this is egregious, the violations are egregious, and attempting voluntary compliance would risk the plan assets, or if the Department of Labor feels that the sponsor would reject the department's proposed correction anyway, then they could just send it on for litigation or criminal prosecution. And that's, I think, unlikely with your group health plan, but you never know. So now turning to IRS potential audit items. Again, even if you're not subject to ERISA, you could be subject to an IRS audit for both Affordable Care Act and non-Affordable Care Act items. And as I said, many benefit requirements are in ERISA and the Internal Revenue Code and the Public Health Service Act. So you could be subject to a lot of these requirements even if you're not subject to ERISA. So first, some potential IRS audit items. These first two items, compliance with the employer shared responsibility and the information reporting, go hand in hand. And they only apply to applicable large employers, affectionately called ALEs. And these are issues under the Affordable Care Act. So these are just new things. You're probably well aware of these if you're an ALE. I'll mention a little bit more in a couple more slides, but on the information reporting, that's your 1094Cs and 1095Cs. Could also be 1094 and 5Bs. So the IRS is looking at, did the employers file these, and furnish them to participants or employees? Was it timely and was it accurate? Now for 2016, for the 2015 filing, the IRS has said we won't impose accuracy penalties, but we still might impose penalties if it wasn't timely filed. And this is what later this year, employers might get a notice of a potential penalty assessment if they didn't offer coverage to at least 70% of their full-time employees in 2015, or if some full-time employees qualified for a subsidy because the coverage wasn't affordable or didn't provide minimum value. And again, the employer mandate requirement is that in order to avoid the A and B penalty, ALEs have to offer minimum essential coverage, or MEC, to full-time employees. And in order to avoid the B penalty, it has to be both affordable and provide at least minimum value. And the penalty only applies if at least one full-time employee qualified for a subsidy to buy insurance in the exchange. Now, to avoid that B penalty, the two of the provisions were affordability and minimum value. So one of the issues on affordability, that's if the employee cost of employee-only coverage had to be less than, it was originally 9.5%, last year it was this year it's 9.66% of household income or of one of three safe harbors. And one of the issues that's come up in the last year is a lot of employers offer opt-out arrangements where they pay employees some taxable cash amount in order if they'll decline coverage under the employer group health plan. And some of the opt-out arrangements, employees had to show that they had other coverage. Other arrangements, they just had to opt out. They didn't even have to show other coverage. So the IRS has issued several different notices on this and regulations, and their position has evolved. So for 2016, the issue is that the IRS said what the employer offers as an opt-out amount is going to count in the affordability test. And so that hurts the affordability test because it means it's counting as an employee contribution and it's increasing the cost for employees So the IRS is probably going to be auditing for this. And in 2016, conditional opt-out arrangements do not count, or even unconditional ones that were adopted before December 16, 2015, but others do. And then starting in 2017, in order for the amount not to count in the affordability test, it has to qualify as an eligible opt-out arrangement. So I think that is something that the IRS will be auditing for in the future. So if you do have or have had opt-out arrangements, make sure that you're counting them correctly and that you're following the rules. And we have several articles that we've posted in the past on that topic. The second area is minimum value. So in order to avoid the B penalty, the other requirement is the plan offered has to pay on average at least 60% of the cost of allowable benefits paid under the plan. And one of the issues that came up on that, which has been kind of an ongoing issue for the past 2 years, is what if an employer offers minimum essential coverage that either doesn't provide minimum value, or initially with the minimum value calculator that was online on HHS, there were some plans that provided 60.1% or 61% of actuarial value, and they did not include coverage of inpatient hospital services and physician services. So the IRS, in their notices listed 2014-69 in their regs, and then in HHS regs, they've taken the position that a plan does not provide minimum value if it does not include substantial coverage of inpatient hospital services and physician services. So I'm sure they'll be auditing for that if you had a plan that appears that it might not have provided minimum value, and a full-time employee got coverage, a subsidy in exchange. There is an exception in the IRS rules for such plans that were adopted before November 4th, 2014. That's when they came out with the notice, 2014-69. And the adopted means there was a binding contract or employees were enrolled. So there's no penalty for the employer until the end of the first plan year beginning after March 1st, 2015. So that could be the end of your 2016 calendar year. So I'm sure that's something that they'll be looking at. If you had one of those kinds of plans, you'll want to be sure you can document it. And that's just the language in the HHS regs saying minimum value means greater than at least 60% and substantial coverage for those services. Now the potential penalties, if it doesn't meet, if it's less than minimum value or if it's not affordable, there's the 4980H A and B penalties. So the other thing, it would protect the employer against the A penalty, but probably not against the B penalty. However, if the employee enrolled in coverage that wasn't affordable or didn't meet minimum value, then the employer would not be subject to a penalty because the employee actually enrolled. But there is this issue with the MEC plans that don't provide substantial services for physician and hospital services. If the employer pays 100% and auto-enrolls the employee, then you have to give the employee the opportunity to opt out and instead get a subsidy. So if you have this issue, it's probably already going to come up first if you get a notice from the marketplace, and then if you later have a notice from the IRS, it'll be the same issue. Another area that the IRS might be auditing for is dependent Social Security numbers. So on the information reporting, if you're an insured plan, this probably isn't an issue for you, but the carrier needs to do this. But if you're a self-insured plan, you probably noticed on the 1094, 1095C reporting that you needed to give either the date of birth or the Social Security number of enrolled dependents. And the Internal Revenue Code does require that you either provide the Social Security number of dependents, or you could be subject to a penalty unless you show that you made a reasonable effort to obtain the Social Security numbers. And so there's rules and the regs, and also this IRS Notice 2015-68, specifically provided that, for example, in a self-insured plan, you need to request the dependent Social Security numbers when they first enroll, and at a reasonable time thereafter, and then by December 31st of the year following the initial request. So with the, probably not for this year, but for next year's information returns, you might end up getting audited or a notice from the IRS if you don't provide, if you're self-insured and you don't provide the employee, so the dependent Social Security numbers. And then you would want to be able to show that you made a reasonable effort. So kind of back to the information reporting, or the applicable large employers were required to furnish the 1095-Cs to full-time employees by March 31st of 2016, and that's the reporting for the 2015 year, and to file the 1094-Cs and 1095-Cs with the IRS by May 31st if it was hard copy filings, or by June 31st if they were filed electronically. Now, I think especially for this first year, the IRS is going to be a bit lenient on those dates. For one thing, they might not know whether you filed by March, whether you furnished the reports by March 31st to individuals. Individual tax returns were due April 15th, but they didn't have to attach those to the tax returns. But if individuals can file for an extension, so they wouldn't file until October 15th, just 5 days ago. So I don't think you'll get any, you may start getting notices from the IRS regarding your information reporting. I think it won't be till after the election, because they couldn't do it until at least after October 15th, even if all the information is there, everyone filed on time, all the computers work perfectly. You know, I don't think those notices would be generated until like today or tomorrow. And my personal opinion is that at this point they're going to wait until after the elections before they send those. So if you do get a notice from the IRS about apparent noncompliance based on the information reporting, you can respond to that IRS notice and appeal that, and then that could end up being the basis for an audit. I mean, we don't know for sure, but that probably could end up being the basis for an audit. Then IRS, again, the due dates, we had the later due dates in 2016 for the 2015 filing, but that was a one-time delay of the due dates. So what it will be for 2016 and going forward is that the 1095-Cs need to be given to employees by January 31st. Then the filing, the paper filings with the IRS are by February 28th, and then electronic filings with the IRS are due by March 31st. So just keep that in mind for next year and later years. Unless, of course, it's all repealed. Who knows? Kind of back to the employer mandate, I showed you the requirements before, and then the penalties, which I'm sure the ALEs are very familiar with at this point. The A penalty is $2,160 a year times the total number of full-time employees minus 30, and that applies if the employer doesn't offer minimum essential coverage to at least 95% of full-time employees. And for that A penalty, it doesn't have to be minimum value or affordable. And that $2,160 is $180 a month. And for last year, it was full-time employee, number of full-time employees minus 80, and it was 70% rather than 90%. And then the B penalty is what was originally the $3,000 penalty. Now that's $3,240 for each full-time employee who gets the subsidy and was not offered minimum value affordable coverage. And that equates to $270 a month. Other potential IRS penalties, again, the employer shared responsibility, and then the information returns that I just talked about. Failure to provide it is $250, and the annual cap is $3 million, or $1 million for small employers. But there's also a reduced penalty amount of $50 per return, 1095C or 1094C, if you failed to provide it but then corrected it within 30 days, and a cap on that, or if it was provided by, if it's provided by August 1st, then it's $100 rather than $250. But just intentional disregard and not providing it, the penalty is $500 per return, and there's no annual cap. So if any of you are in that boat where you still haven't provided it and you determine that you should have, you could still go ahead and file the information return, and at least your penalty cap would be $250, not $500 per return. And then this page is just a reminder on the employer shared responsibility dollars and the percentages for 2014 and 15 and 16. I won't go through that, but it's just a handy page to have if that applies to you. Also, potential IRS audit items. Other items besides the ones I just mentioned, employer shared responsibility and the penalty and the information reporting. Again, the ACA market reforms and other rules, but some of the same market reforms that were under ERISA. I mean, they're in the Affordable Care Act, and it amended sections of ERISA as well as the Internal Revenue Code as well as the Public Health Service Act. So these requirements apply whether or not you're subject to ERISA. The annual and lifetime limits, the patient's Bill of Rights, the payment for emergency services, the payment for preventive services, the MLR rebates and refunds, also the limits on waiting periods. The IRS also has jurisdiction over the PCORI fees, the Patient-Centered Outcomes Research Institute, because the employer pays those using the Form 720. And then comparability rules for HSAs and the non-discrimination test for cafeteria plans under Section 125, for dependent care plans under 129, the non-discrimination test for self-insured plans under 105H, and eventually the non-discrimination rules that will apply even for insured plans. But the IRS has delayed those to some indeterminate date. But those are other things that the IRS could be auditing for, and it's possible that if the DOL audited and found irregularities, they would notify the IRS. Also, employer premium payment plans are something that have been a big issue and that the IRS has said is not okay. And let me talk more about those in just a minute, but I just want to note the penalties for non-compliance with some of these is under IRC Section 4980D, and I'll talk about that a little bit more in a later slide, and that's the $100 a day excise tax. And if the employer has violated any of those requirements, the employer should file the Form 8928. So, if you have a question, do we know the limits and penalties for 2017? What's affordable pay or play penalties? No, I don't know those yet because for example, the federal poverty limits are issued in January of each year. So you can use the 2016 amounts even for 2017. I'm sure that they are being estimated by some people because they're based on cost of living increases. So those are, somebody has issued those. I believe the 2017 affordability percentage might be 9.69, but I would need to confirm that. Okay, so employer payment plans, what the IRS has said is that employers cannot directly pay for and they cannot reimburse employees for the cost of individual health insurance policies. And that applies whether they buy them in the marketplace or exchange or off the marketplace. And the IRS has issued a number of notices on this. Some vendors still insist that it's allowable under Internal Revenue Code Section 105 and 106. And so some employers might still be offering these kinds of plans or might have been offering them. I think this is something that the IRS will audit for. The IRS has said these types of arrangements, the employer premium payment plans, are group health plans. They're subject to the ACA market reforms, and that particularly the two things they would be in violation of are the prohibition on annual limits, because they're only reimbursing a certain amount, whatever the amount is, and the requirement to provide preventive care without cost sharing. And the IRS notices have said that an employer cannot you can't integrate these payment plans with individual policies in order to satisfy the market reforms. You can integrate them with group health plans. So the IRS has issued various notices saying it's not okay since September 2013, and I've listed some of them there in the IRS webpage on employer health care arrangements. And the IRS has specifically said it doesn't, in some of the notices it specifically said violations of this, will incur the 4980D penalty, and it's $100 a day, and that's $36,500 per year per affected participant. So, I mean, one interpretation of all that is that the IRS is letting people know, hey, we really are going to be enforcing this, and here are the penalties. So, hopefully no one is doing that. Another area is these double-dipping wellness banks. And the IRS issued Tax Memorandum 2016-22-031 a few months ago this year. And so if you have one of these wellness programs, you should be able to document why it is in compliance. It's a wellness program where it's not just where the employee pays in order to participate in the wellness program. So it's not the traditional type of wellness program where the employer provides it and employees get paid an incentive or a reduced premium cost if they meet the requirements. It's a wellness bank where employees, it's a defined benefit wellness plan, and employees pay a premium to participate in it, and then they earn either non-taxable or taxable cash rewards from the wellness program for participating in certain activities like the biometric screenings or the health risk assessment or seeing a health coach. And under a traditional wellness program, an employee might get rewards for those same things, but the employee didn't pay in the first place to participate in the plan. And under the plan, the employee is paying on a pre-tax basis, so that amount is being excluded from income taxes and employment taxes. So that's saving the employer 7.65% also on employment taxes. So the IRS has looked into this. They've issued this notice. I think it is something they'll be looking for if they're doing an audit. Some other potential IRS audit items that are Affordable Care Act items. Other things the Affordable Care Act required is the additional 0.9% Medicare tax on employee wages or compensation in excess of $200,000. Also, employers have to report the cost of employer-provided health insurance coverage on the employee's W-2, and there's an exception if you didn't file at least 250 W-2s in the prior year, but that's probably something the IRS will be looking for if it audits. And third was the PCORI fee timely paid, and that's if you have a self-funded plan, that's the employer obligation, whereas if you're insured, then the carrier would have paid it, so you wouldn't have to worry about it. But if you're a self-funded plan or a level-funded plan, if you change from insured to self-insured, then that's something you would have needed to pay. Another area for potential IRS items is if you're a small business, did you claim the small business health care tax credit? And if you did, were you eligible for it? Did you meet the requirements? So and I think that is something that has not been widely used, but if you did use that, be sure you're compliant. So the IRS penalties, I noted some of these previously, the employer shared responsibility and the information returns. The other thing I mentioned is the 4980D and the Form 8928. So again, that's the penalty, that's the $100 a day excise tax per affected participant. Also, if an employer didn't comply with any of these requirements, it should report on the Form 8928, and if it doesn't, there are penalties for late payment and late filing of the return, and also there's interest on the unpaid amount. The last area I have to cover is the HIPAA enforcement, or the HIPAA audits by the Office for Civil Rights. And these are, the OCR can investigate complaints, it can initiate compliance reviews, and it also has this proactive HIPAA audit program. And they did phase 1 of the audit in 2011 and 12, and now doing phase 2 in 2016. And if OCR finds a violation, it can either require voluntary compliance, which is mostly what they've done in the past. It can have corrective action. It can require you to do certain things, or it can have a resolution agreement. And that's sort of like the DOL closure letter. They state the facts of the violation, require the covered entity or the business associate to make payment and implement a corrective action plan, and then they also post these resolution agreements on their website. They can also impose civil monetary penalties and criminal penalties, and that's done through the Department of Justice. So what exactly do the privacy and security rules require? Well, if you have a group health plan, that's a type of covered entity. And so the privacy rules basically say, in order to disclose or use PHI, protected health information, for purposes other than treatment, payment, or healthcare operations, you need to get an authorization from the individual to use their PHI. And it also has a minimum necessary rule. You can't use more than the ask for or give more than the minimum necessary amount of PHI for the situation. There are also certain rights that health plan participants and patients have, so you have to respond to their requests if it's their rights, like to limit how you share their PHI or how you get back to them. And then covered entities and business associates also have to have certain administrative procedures and ensure workforce compliance. And that applies for the security rules as well as the privacy rules. And then the other part of the security rules is protecting electronic PHI against threats or hazards to the confidentiality, integrity, and accessibility of the electronic PHI, and securing electronic PHI both at rest and in transit. So as an employer group health plan, as being one category of a covered entity that's subject to HIPAA, if you're the plan sponsor of the group health plan, then you have those privacy and security obligations. So here's kind of an easy checklist of the major obligations. Appoint a security officer and a privacy officer. Conduct a risk assessment of the risks and vulnerabilities to the confidentiality, integrity, and availability of ePHI. And you might, in the risk assessment, you might say, well, we're fully insured, we don't access PHI, so that really limits what you would have to do. But you need to show that you did some kind of risk assessment and looked at it in the first place to determine whether you do have PHI, and if so, what you have and where it is. So then if you do have it, you would need to implement the policies and procedures, train employees who work with PHI or in close proximity to it. You have to have business associate agreements with your business associates. If there is a potential breach of PHI, you need to conduct a risk analysis, and then if there was unless you can show that it's unlikely that there was a breach, there are certain breach notification obligations that you have to meet. Also, if you have a covered health plan, group health plan, it's a covered entity, you need to respond when participants exercise their privacy rights. And you also need to post and distribute privacy notices to participants if you had access to PHI. Now, if you're insured and you had no access to PHI, you can rely on the carriers to distribute their privacy notices. And then you'd also need to revise and update your plan and your SPD and your authorization form. The HIPAA notices, I just want to mention the November 23rd, 2013, the privacy notices were revised, and HHS issued sample model privacy notices. So every 3 years, a plan needs to either send new notices or send participants a notice saying you can request a copy of the privacy notice. So if you don't already send it out annually, which many people do, then probably by November 23rd of this year, you would need to send it out. So phase 2 of the OCR audits, they've said, and here's their website is listed at the bottom of the page, they've said they're going to use the audit program to assess the compliance efforts of covered entities and business associates. So they're doing first desk audits where they'll request that you send information electronically to their portal, and then they may also do in-person audits. So the thing they've said that they're going to ask for and that plan sponsors should do is look at your HIPAA privacy and security policies, whether you've performed a risk assessment, look at your breach notification procedures. They're going to ask for a list of business associate agreements. So if you do have business associate agreements, probably put together a list of them and ensure that the workforce is trained on the HIPAA requirements. Now, the potential penalties for violations are basically the maximum for each per year is 1.5 million, although you probably wouldn't reach that, but it's probably going to be the 100 to 50,000 per violation, or really the 1,000 to 50,000 per violation. And so that's a wide range of discretion that OCR has in terms of what penalty they would impose. One thing I want to point out, however, is for HIPAA violations that are corrected within 30 days, there is no penalty if the violator didn't know and wouldn't have known exercising reasonable diligence that they were violating HIPAA, or even if the violation is due to reasonable cause and you show it was not due to willful neglect and you correct it within 30 days. However, the penalties do apply if, even if it was reasonable cause, not willful neglect, but you don't correct it within 30 days, or if OCR says, well, it was due to willful neglect, they can impose a penalty even if you do correct it. And then OCR can also impose criminal penalties if someone knowingly obtains or discloses individually identifiable health information. And the criminal penalties, and I don't think these would apply to any of you, but just keep in mind it's 50,000 up to 1 year imprisonment, up to 100,000 and 5 years imprisonment, and 250,000 and 10 years imprisonment if it involves intent to sell, transfer, or use identifiable health information for commercial advantage or personal gain or malicious harm. And again, the Department of Justice is responsible for the criminal violations. Let's see, I have a question. Can you explain how a group with 50 that is fully insured is off the hook for privacy and security? Well, I wouldn't completely say that they're off the hook, but if they're fully insured and they don't get PHI, you probably still want to have someone who's the privacy official and show that you did some kind of risk analysis to say, oh, what is PHI, do we get any, and that you determined that you don't get any PHI. And maybe even have a statement that says, our intent, we've done this analysis and we believe we don't get PHI and our intent is not to get PHI. Because sometimes the issue has been, if I would talk to clients in the past and they said, oh, we don't get PHI, and then I would explain to them, well, these are some examples of PHI, then some employers would say, oh, well, yeah, we do get that. Oh, yeah, we do get that. So you don't want that to be an issue. And, for example, even if you're fully insured, if you have a health reimbursement plan, a health FSA, or an HRA, even if you have a TPA, the plan that's the health FSA or the HRA is a self-funded plan, so you want to have a business associate agreement with the TPA, and you want it to say, you handle it all, we don't get PHI. So you would want to note that in your business, in your risk assessment, that even though you have the health FSA or the HRA, it's completely administered by the outside CPA, and that they have any PHI they have, and it's not shared with the employer. So let me just talk about the breaches affecting 500 or more individuals. If there is a breach affecting 500 or more individuals, there is, it has to be reported to HHS as soon as possible, within 30 days, and it's posted on what's often called the wall of shame. So it's on the HHS website. It's, the URL is at the bottom, the ocrportal.hhs.gov, and then it lists the covered entity and the business associate and what type of breach occurred and how many individuals were affected. So you don't want your company's name on this list. But you can look at that list, and it goes on for pages and pages for a number of years. You can sort by state, by type of breach, and it includes brief summaries of the breach cases that OCR has investigated and closed, and the names of the private practice providers who have reported the breaches of unsecured PHI. So that's not exactly a penalty, but that is one of the outcomes, potential outcomes of having a breach. Oops, let me go back up. So the best way to be prepared for an audit, first of all, know what's required, whether it's under the Affordable Care Act or HIPAA or ERISA or the Internal Revenue Code, and then make sure you are compliant. So do a self-audit and look at being in compliance in operation as well as having compliant documents. Because if you're audited, they're not just looking at your documents usually. Maybe phase 2 of the HIPAA audits, initially they're only looking at the documents, but then if you're one of the entities that's contacted, so it's more than just submitting documents, they're looking at were you compliant in operation as well as were the documents on their face compliant. The other thing you should look at is if there were required notices, make sure they were timely sent and to the right people, and make sure you can document your compliance. So not that you have to have, I mean, you might have a list of plan participants, in 2014, and the dates when the particular notices were sent to everyone and how they were sent. Or if they're sent electronically, the email that you sent to everyone and showing that you filed the electronic distribution rule. Because those are the kinds of things that the Department of Labor would be asking, particularly on disclosures and that they were accurate. So use our checklist, the different checklists we have, and I would say organize your files so that it's easy to show your compliance. And that's one reason that DOL checklist is really helpful, because it's what the DOL requests in their audits, and they have, again, they've sent out the attachment A to their audit letters, so they're letting everybody know. It's a good way to organize your files. A lot of it is documents that you probably already have, but this kind of helps you organize them in a way that if you do get a notice from the DOL or the IRS, you can readily produce it. You're not having to go too far to find it. Again, though, you might have an issue with if you've changed carriers in prior years and you don't have good documentation from 3 or 4 years ago, and then trying to get some of that documentation. So again, spend 15 or 30 minutes whenever you can just to get your files in order. I would say start with the most current year, though, and get your current year in order. And the other thing is stay updated with healthreformupdates.com, also news.leavitt.com. This is a screenshot of a fairly recent screenshot, which shows some of the the articles that we've posted recently. And thank you very much. Let me see what other questions I have. What are some examples of often overlooked PHI? I'm not sure what might be often overlooked. It would be information on employees and that identifies individuals, health plan participants, and that has that has health information. Maybe one thing is you should have, if you have authorizations, those authorizations themselves would be PHI. So they should be kept securely because the individual is putting their name and telling what medical records they authorize release of or disclosure of, or what ones they don't. Also, they might be specifying that. So the authorizations themselves would be PHI. Also, you should be keeping a list, or a covered entity or a business associate should be keeping a list of any unauthorized disclosures that they've made. And some of these could be inadvertent. For example, if you fax something to the wrong person. So, and sometimes people aren't keeping any list of those items, or employees don't want to tell that they've actually, you know, inadvertently sent an email to the wrong person. I mean, sometimes, you know, with Outlook or emails, it pre-populates, and you might have several people with similar names, and so you start typing in someone's name, and it puts in the wrong name, and you're in a hurry, and you're sending it to several people, and you hit the send button. So that's sometimes what happens. So you need to take steps to mitigate that and say, you know, send an email right away saying this information was sent to the wrong recipient. Please delete this as soon as possible and don't read it. It contains PHI. Or, you know, an attachment was sent that should have been encrypted and it wasn't. But those might be some of the kinds of things that would be often overlooked. Someone else asked, can we get a printout of the presentation? It is, I will, in fact, I'll see if I can either get it attached. You can get it from your Leavitt or GBS advisor. We have it posted internally, so they can send it to you if you give them a call. And I may try to see if I can get a PDF attached. If the system will include it, it'll send a follow-up message tomorrow and say thank you for attending, and it will hopefully give you a link to a recording, a YouTube video of it. I don't know if I can also attach something that goes out to that many people. I think it doesn't send an attachment. So probably the best thing is to contact your Leavitt or GBS advisor and have them send you a copy of the presentation. So, okay, that is it. I really appreciate everyone signing up and hanging in and listening to it. If you have other questions, please give us a call. Thank you.